All right, very good. Let's get to the proceedings here. Let me see if both teams are ready. Is the prosecution ready for trial?
Yes, Your Honor.
And is the defense ready?
After a few preliminary matters, Your Honor.
Okay. Let me come back for those preliminary matters in a second, and let me go through some of the rules for everybody. We've got your trial roster, we've got our video. The Colorado Bar Association may be videotaping this or taking photographs of the screen, just so you're aware of that. Please, no interruptions from anybody who might be outside the virtual courtroom. Keep in mind, we won't have any recesses with the exception of those granted for a health emergency. Okay, so obviously if there's an emergency, let me know and we'll take a recess. Otherwise, no recesses. Let me turn to our panelists and ask if any of our panelists have any kind of conflict as they are looking at the screens of our participants today. Ms. Linden, any conflict? We may be having some Zoom issues.
No conflicts.
Okay, thank you. Ms. Canese, any conflicts? Ms. Canese, any conflicts for you? No conflicts, Mr. McKenna, for you?
No conflicts, Judge.
A reminder for the teams and coaches that any disputes arising out of the competition must be reported in accordance with the competition rules. Remember, your compliance with the time requirements will be considered in scoring individual performances. If we could do introductions of team members, starting with the prosecution.
Yes, Your Honor. Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and I will be giving the opening statement, the direct examination of Alex Cifuentes, and the cross-examination of Blake Van Owen.
Your Honor, opposing counsel, members of the jury, my name is Brendan Maher. I will be delivering the direct examination of Kyle Kuzak and the cross-examination of Taylor Perkins.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Will Damon, and I'll be delivering the direct examination of Jordan Markowitz, the cross-examination of Avery Becker, as well as the delivering of the closing argument. At this time, our witnesses would like to introduce themselves.
Your Honor, opposing counsel, and members of the jury. My name is Vi Wing, and I am Jordan Markowitz.
Your Honor, opposing counsel, and members of the jury. My name is Jet Fisher, and I am Kyle Kuzak.
Your Honor, opposing counsel, members of the jury. My name is Crystal Caruana, and I am Alex Cifuentes.
All right, I think that's everybody for the prosecution. The defense?
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Peter Briggs. I will be delivering the opening statement, the direct examination of Avery Becker, as well as the cross-examination of Kyle Kuzak.
Your Honor, opposing counsel, and members of the jury, my name is Zoe Mans-Jackson, and I'll be providing the direct examination of Blake Van Owen and the cross-examination of Alex Cifuentes.
Your Honor, opposing counsel, members of the jury, my name is Jessica Bustillos, and today I'll be providing the direct examination of Taylor Perkins, the cross-examination of Detective Jordan Markowitz, as well as providing the closing argument. Our witnesses will now introduce themselves.
Good evening, Your Honor, opposing counsel, and members of the jury. My name is Olivia Delfalo Daly. I am Professor Blake Van Owen, your first witness.
Your Honor, opposing counsel, and members of the jury. My name is Eleanor Briggs, and I am Taylor Perkins, the second witness.
Your Honor, opposing counsel, and members of the jury. My name is Jaylee Hepner. I am Avery Becker, your third witness this evening.
All right, I think we have everybody. Let me administer the oaths for people, one group at a time. Team members, if you would raise your hands. and repeat after me or follow me. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
I do.
Thank you. Witnesses, please raise your right hand. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your
I
Honor.
do.
I do, Your Honor.
I don't think we need to do gallery members. Scoring panelists, if we could have our panelists raise their right hands. Scoring panelists, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
All right, thank you. I know we had some preliminary issues, at least from the defense, but let me start with the prosecution. Did the prosecution have any preliminary issues to address?
Yes, Your Honor. On behalf of both teams, Your Honor, we request the court's preference on redirects and recrosses.
As to whether they're allowed or not?
Yes, Your Honor.
Any objection from the defense to having redirect and recross?
No, Your Honor.
All right, so ordered, that's allowed.
Your Honor, pursuant to Rule 704, when an exhibit is shown to a witness, a member of the examining attorney's screen shall make that document available via the Zoom screen sharing function. Additionally, exhibits and other documents posted in this manner will deem to not have been shown to the jury until they are admitted into evidence and formally published.
Any objection from the defense?
We will have no objection to whatever method of exhibit instruction Your Honor prefers. However, we do have a method in which the jury will not see the evidence before it's admitted and published.
Okay, very good then. Those requests are granted.
We recognize that sound quality and internet connectivity may vary, and if any time the sound quality makes it difficult to understand, we ask that the court pause proceedings to allow the witness or attorney to repeat their question or answer.
All right, very well. We will definitely do that. Any other issues from the prosecution?
We request that timekeepers be allowed to post time remaining in the chat throughout the trial.
Any objection?
No, Your Honor.
So ordered.
And the prosecution requests that we request remaining time for prosecution closing argument be reserved for rebuttal.
All right, very good. Any other issues from the prosecution? Hearing none, we'll turn to the defense. Preliminary issues for the defense.
Yes, Your Honor. For purposes of the virtual competition, may we consider, may we publish to the jury, opposing counsel and Your Honor, our trial roster as well as the stipulations?
Yes.
Thank you. Although Rule of the Competition 5.1.1 requires attorneys to stand during opening statements and closing arguments, because we're virtual, we ask that the court waive that requirement for both teams.
So waived.
Your Honor, finally, as the defense, we'd like to make a motion in limine pursuant to Rule 5.3.3 of the competition. We ask that the court exclude all testimony from Jordan Markowitz commenting on the defendant's attorney canceling an interview with the detective, the grounds being that this is an inappropriate comment on the defendant's right to remain silent.
Prosecution response to that motion in limine?
We object to that motion on the grounds that the evidence would not be prejudicial in any way to the general public, as well is well versed in the fact that you don't have to try and speak to a police officer if you don't want to, and that doesn't mean that you're guilty, as we don't think that this evidence is prejudicial at all.
So I'll overrule the objection for now, but I can revisit it when the issue comes up. Anything else from the defense?
No, Your Honor. The defense is prepared for trial.
Very well. Let's hear opening statements, starting with the prosecution.
A moment to readjust.
Yes.
Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and my co-counsel and I are here today on behalf of the people of the state of Colorado. Revenge is a powerful motivator. On March 6th of 2020, a tragedy occurred. A well-known attorney and well-respected coach, Mackenzie Brackman, was found dead in his home. On March 6th of 2020, Avery Becker broke into Mackenzie Brackman's home. Unaware that Mr. Brackman was in his home, the two engaged in a physical struggle. It is our assertion that in this physical struggle, Avery Becker took a knife and stabbed Mr. Brackman in the upper left-hand shoulder, nicking his aorta and causing him to bleed to death. After leaving him dead in the entryway of his own home, Avery Becker then fled the scene. The relationship between Avery Becker and Mr. Brackman has spanned for 4 years since Avery Becker started on the mock trial team her freshman year. During the entirety of this relationship, bad blood was a constant. Mr. Brackman and Avery would constantly disagree on Avery's work ethics. Avery would constantly show up to practices late, as well as come unprepared for competitions. This led Brackman to be hard on Avery, and Brackman encouraged her to work harder and called out the her persistent harmful antics that hurt her team. Confrontation was not something that Ms. Becker liked, and this led for her to carry a disdain for her coach. This disdain grew further as a result of not being able to meet Mr. Brackman's expectations. Avery was demoted to a lower team. After being demoted to a lower team, Avery then got her friend Taylor Perkins to to leave her spot on A team, therefore forcing Mr. Brackman to reinstate her into a higher position again. After the regional competition, Mr. Brackman confronted Avery about how unfair she was being to her team and asked that she improve her work ethic once again before state competition. Avery took this feedback as an attack against her, and this led to a reckless decision that was motivated by her need for revenge. Avery took a permanent marker and wrote across the hood of her coach's car, "Worst Attorney Award." This was the boiling point, the last straw, and Mr. Brackman kicked Avery off the team for good. This gave Avery an opportunity once more to seek revenge, to commit her crime. We will put forward 3 witnesses today, Detective Jordan Markowitz, Kyle Kuzak, and Alex Cifuentes. Detective Markowitz will testify today to how Mackenzie Brackman was killed, providing you with an expert opinion on homicide investigation from his years of expertise at the Denver Police Department. Detective Markowitz will walk you through the events that transpired on March 6th leading up to Mr. Brackman's death. Detective Markowitz will point out Avery's opportunity in committing her crime. Kyle Kuzak will present his expert opinion that proves that a scuffle did occur when Avery Becker broke into Mr. Brackman's house on March 6th. This evidence will detail the means in which Avery Becker committed her crime and killed Mr. Brackman. Finally, Alex Cifuentes will testify on behalf of her personal knowledge with the defendant, from being on the mock trial team with the defendant, Avery Becker, Coach Brackman, and defense witness Taylor Perkins. Alex Cifuentes will help explain the motivation behind Avery's revenge. Avery Becker is charged with first-degree murder and second-degree burglary of a dwelling. It is not our duty as a prosecution to prove to you today Avery's intent in killing Mr. Brackman. Instead, we will prove to you that Avery Becker broke into Mr. Brackman's home with the intent of criminal mischief, and a tragic death occurred, leaving Avery Becker guilty of first-degree murder and second-degree burglary of a dwelling. The prosecution carries the burden of proof in today's case, a burden that we will indeed meet. And we will ask you, the jury, to return a verdict finding Avery Becker guilty of first-degree murder and second-degree burglary of a dwelling, because the revenge Avery sought was a powerful motivator. Thank you.
Counsel. We'll turn to the opening statement for the defense.
Your Honor, opposing counsel, and members of the jury, good evening. Avery wasn't there. She and Taylor were looking everywhere. On the morning of March 6th, Avery Becker awoke to the startling realization that she had lost her phone. And so for that entire day, while someone else was killing Coach Brackman, Avery was with Taylor Perkins searching for that phone. Avery wanted to repair her relationship with her coach, and that day they went nowhere near his house. Members of the jury, the burden of proof lies on the prosecution. They must prove to you beyond a reasonable doubt that on or about March 6th, Avery Becker broke into the residence of Mackenzie Brackman with the intent to cause criminal mischief and thereto cause the death of her late coach. This burden exists because the law demands that juries assume every defendant innocent until proven guilty beyond a reasonable doubt. Yet at the close of the evidence tonight, you will see that this proof is non-existent. It's insufficient. Because we, as the defense, do not have any legal burden of proof, but nevertheless, we will show you the innocence in the courtroom today by highlighting a lackluster police investigation riddled with mistakes and assumptions. You will hear from 6 witnesses. First, 3 from the prosecution. The prosecution will bring you Kyle Kuzak, a crime scene reconstruction investigator who, as a civilian consultant to the police, will tell you a story. However, Kuzak will provide no evidence linking Avery to that story, to the crime scene. You will see that only through a series of assumptions is Avery held at fault. Further, the prosecution will question Detective Markowitz, the police officer charged with investigating this murder. Markowitz will insist that cell phone tower data places Avery's phone in Brackman's neighborhood, but will provide no evidence that Avery's phone was on her person, that they were in any way at the same location. The prosecution will also question Alex Cifuentes, a former teammate and classmate of Avery Becker. With a clear bias against the defendant, Cifuentes has failed to provide their phone to the police for the investigation, and hence any evidence derived from this phone should be taken with a heavy grain of salt. After this, you will get the opportunity to hear from 3 witnesses from the defense, starting with Blake Van Owen, an expertly qualified private investigator who will outline that in this modern era, there are many ways in which a digital image can be tampered with, underlining why the evidence derived from Alex Cifuentes' phone should be questioned. Further, Blake Van Owen will highlight the assumptions made by Kyle Kuzak and the shortcomings of the official investigation conducted by Detective Markowitz. For example, Blake Van Owen will introduce you to an alternate suspect named Blair Rollins, with strong motive, who has disappeared to this day and went relatively uninvestigated by the police. As a defense, we will also bring you Taylor Perkins, who will corroborate Avery's alibi. Not only was Avery searching for her phone the entire day, but she was with Taylor. This testimony will cement in your minds Avery's innocence before we even get to our 3rd witness, the defendant herself. When Avery Becker takes the stand, she will describe in detail her activities the day of and time of the murder. Avery Becker will explain how she lost her phone and describe the true sentiments between her and her coach, dashing any motive cast by the prosecution. Members of the jury, the prosecution will use the creativity of Kyle Kuzak to cover a lackluster police investigation, using assumptions to fill holes where facts are missing. But don't let this fool you into perceiving a coherent story. The defense witnesses, on the other hand, will present a unified, cohesive front centered around the simple fact of the corroborated alibi. At the close of the evidence, my co-counsel Jessica will implore you to reach a verdict of not guilty, because the assumptions that form the foundation of the prosecution's case will be apparent to you, and the defense will have revealed the truth of the events on March 6th. There will not be enough proof, enough evidence to convict this high schooler to a life of prison for a crime she didn't commit, because Avery wasn't even there. She and Taylor were looking everywhere. Thank you, Your Honor.
Thank you, counsel. We'll turn to the prosecution's first witness.
Yes, Your Honor. The people would like to call Detective Jordan Markowitz to the stand.
Go ahead.
Good evening. Please state and spell your last name for the record.
Jordan Markowitz, Markowitz.
And what do you do for a living?
I'm a homicide detective at the Denver Police Department.
How long have you worked as a detective?
Well, I've been at DPD for 13 years and have been a detective for 7 years now.
What sort of certifications do you have as a detective?
Well, I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. It instructs you on how to obtain and interpret cell phone records and data, as well as cell layer data and cell tower data.
How often do you use your certification?
Well, I use it on a daily basis. In fact, I've used it in over 50 cases.
Your Honor, at this time, pursuant to Rule 702, I move to enter Detective Jordan Markowitz as an expert in homicide investigation with an emphasis on cell phone technology.
Any objection from the defense?
Permission for a brief audio, Your Honor.
Yes?
Okay. You're a homicide detective
That's right.
with the Denver Police Department.
Yes, like I stated.
You've worked with the Denver Police Department for 13 years.
Yes, I have.
And as a detective for 7 years.
That's right.
You feel qualified as a homicide detective
Yes,
because you've done so much training to be one.
that's right.
And you've worked in the field for a while.
I have.
You studied to be a detective for years.
I did.
People who don't spend time in training are less qualified for the job.
Yes, that's right.
In fact, that applies to any job.
Yes,
You wouldn't trust someone who only had 2 days worth of training to be a detective.
no, I would not.
You still wouldn't trust them even if they had 3 days of training.
No,
Because to become skilled at a trade, you need more than a few days of training.
that's right.
However, you are fairly new to cell phone technology.
Somewhat, yes.
And forensic data recovery.
Yes.
And you only had 3 days of training to become certified.
Yes, but it was an intensive training course that I had to pass a test to receive my certification for.
So that's a yes, you only had 3 days of training to become certified.
Yes, that's right.
And you admitted earlier that 3 days of training isn't enough to become qualified in something.
No, but like I said, that it was a thorough intensive training course and I had to pass a test for my certification.
You did admit earlier, though, that 3 days wasn't a sufficient amount of time to learn a trade properly.
Objection asked and answered.
Response?
Your Honor, the witness didn't actually answer the question the first time she did. She just offered an explanation that wasn't really related to an answer.
Your Honor, if I may respond.
Yep.
The witness clearly gave a yes answer at the beginning of her answer, but she's allowed to elaborate as it did call for more than just a yes or no. So,
Objections overruled?
Your Honor, at this time, I have no objection to the witness being entered as long as she stays within the scope of what she's being entered as.
All right, the witness will be so admitted as an expert.
Detective Markowitz, let me take you back to March 6th of 2020. Where were you on that day?
Well, on Friday, March 6th, we received a report from a passerby who saw a person possibly passed out at 444 South Flower Street. We were then called in to investigate the scene.
And when you got to 444 South Flower Street, what did you see?
Upon our arrival at 2:20 p.m., we discovered the victim, Mackenzie Brockman, deceased inside the front door. Additionally, the front door was open. We took pictures of the scene as we found it. There was also
Sorry, finish your response.
There was also a knife found near Mackenzie Brockman.
Would you recognize some photos from the crime scene if I showed them to you today?
Indeed, I would.
Your Honor, permission to show the witness what has been marked as Exhibits 1 and 5.
Yes.
And Detective, what are these?
These are the photo of the knife I found near the victim, Mackenzie Brockman.
Are these fair and accurate representations of what you saw on that day?
Indeed, they are.
Your Honor, at this time, I move to enter Exhibits 1 and 5 into evidence.
Any objection?
No objection, Your Honor.
1 and 5 are admitted.
Your Honor, move to publish.
Granted.
Detective, can you describe how you found Mackenzie Brockman?
Yes. I found Mackenzie Brockman face down in a large pool of blood as his shirt was soaked with blood in the upper left back and shoulder area. As along with the knife found near his body, there was blood splatter on the ceilings and walls, which made it quite clear that Mackenzie Brockman was stabbed.
After examining the body, what did you do?
After that, I noticed a Ring doorbell camera, which led me around to the side gate that was unlatched. I also noticed that the back door was open and unlocked.
What happened after you found the back door unlocked?
I then entered through the back door into the kitchen to find the residents in slight disarray. There was a broken plate on the floor, a knife drawer open, as well as blood drops on the floor.
Would you recognize photos of that knife drawer and that broken plate if I showed them to you today?
I would.
Your Honor, at this time, permission to show the witness what has been marked as Exhibits 7 and 9.
Yes.
Your Honor, I don't have objection to that, but we did just lose our timekeeper, so he could be allowed back in the meeting.
Okay. Should we you want to take a pause for that person to get back in?
Yes, please.
Let's just take a brief timeout here while that person gets back on.
I'm under the impression that our timekeeper is in the waiting room, but is just, oh, there she is.
Okay, do we have the timekeeper now?
Yeah, could the opposing counsel's timekeeper also give our timekeeper what time she's at, just so we can make sure we're on the same page there?
All right, can the prosecution timekeeper do that?
Yes, Your Honor.
Looks like we have it now in the chat. Are we all good from the defense?
Yes, Your Honor.
All right, we'll resume the direct examination again.
Your Honor. Can we have Exhibits 7 and 9 pulled up for the witness, Your Honor?
Very good. 7 and 9.
And Detective, what are these?
These are photos of the knife drawer that I discovered, as well as the broken plate I found.
Are these fair and accurate representations of what you saw on March 6th?
They are very accurate.
Your Honor, at this time I move to enter Exhibits 7 and 9 into evidence.
Any objection to 7 and 9?
No objection, Your Honor.
7 and 9 are admitted.
Move to publish.
Granted.
Detective, after examining the kitchen, what did you do?
I continued to search the residence of Mackenzie Brockman and noticed nothing of value was missing. In addition to that, I downloaded the data on Mackenzie Brockman's phone that gave me access to his Ring security camera account. On that account, I discovered 4 videos of a hooded and masked individual that entered the residence.
After downloading and searching Mackenzie Brockman's phone, what did you do?
In addition to that, I noticed that Mackenzie Brockman was part of a thing called mock trial. So later I was contacted by a student named Alex Fuentes, who gave me screenshots of a text message that between her and another student named Avery Becker.
Would you recognize those screenshots if I showed them to you today?
Indeed, I would.
Your Honor, permission to show the witness what has been marked as Exhibit 14.
Granted.
Detective, what are these?
These are the screenshots that I received from Alex Fuentes.
Are these accurate depictions of what you received?
They are indeed accurate.
Your Honor, at this time I move to enter Exhibit 14 into evidence.
Any objection to 14?
No objection, Your Honor.
14's admitted.
Move to publish.
Granted.
Detective, after receiving these screenshots, what did you do?
I then contacted Avery Becker to interview her, but unfortunately I was blocked by her attorney, which led me to get a warrant to search Avery Becker's phone instead.
What did you find with Miss Becker's phone?
Well, technically, I never found Miss Becker's phone, as her phone had been lost since March 5th, the day before Mr. Brackman's homicide. I then got a court order instead to search Miss Becker's cell provider records.
And what did you find with the cell provider records?
Well, through that, I was able to access call detail records, or CDRs for short.
And what are call detail records?
Well, CDRs are what service provider collects when a phone connects to a cell tower. So for instance, if you looked at a nearby tower, you can actually pinpoint where a phone is. So while that call detail records don't provide what is said in these communications to the tower, it can detail whether a call or text message was sent or received and how long a call
Objection,
lasted.
Your Honor.
What's the objection? What's the nature of the objection?
Oh, I'm sorry. I can restate it. Narrative.
Response?
Your Honor, I can break up the question.
Very good. Sustained.
Detective, what is the most important thing about call detail records?
Well, the most important thing is the CDRs can identify which cell tower that phone communicated with.
And how do cell phones interact with cell towers?
Well, there's a complicated algorithm that determines which cell tower a phone will communicate with, but most of the time it connects to the nearest tower. However, it can connect to another tower if the nearest one is full and overloaded, but that is highly unlikely.
What call detail records did you find concerning Miss Avery Becker's phone?
Well, on March 6th, leading up to the time of Mr. Brackman's homicide, Avery Becker's phone received numerous communications to cell tower 1227-3, as well as cell tower 1191-1 and tower 1197-1. I actually created a diagram that details these CDRs.
Would you recognize that diagram if I showed it to you today?
Indeed, I would.
Your Honor, at this time, permission to show the witness what has been marked as Exhibit 15.
Granted.
And Detective, what is this?
This is the diagram I created that details all the CDRs of Avery Becker's phone on March 6th.
Is this a fair and accurate representation of that diagram?
Yes, it is.
Your Honor, at this time, I move to enter Exhibit 15 into evidence.
Any objection to 15?
No objection, Your Honor.
15's admitted.
Move to publish.
Granted.
Your Honor, at this time, I ask that my witness be allowed to annotate on the document for demonstrative purposes in explaining her expert opinion regarding.
Very good.
Detective, can you elaborate on those call detail records?
Yes, so at 12:47 p.m. on March 6th, Avery Becker's phone received a text message at cell tower 1227-3, as I am circling. One moment, Your Honor. It seems as if my annotation tools are not working.
All right, we'll wait.
Sorry, Your Honor. And then in addition to that, at 12:55 p.m., Avery Becker's phone received another text message at cell tower 1191-1 that I have circled. So,
and what does that signify?
Well, this signifies that since the first text message received, which is the cell tower closest to Avery Becker's home, it indicates that Avery Becker most likely took Rock Creek Parkway, as I am highlighting, to get to the address of Mr. Brockman's house.
Did you find any other call detail records?
Yes, in addition to that, a call was received at 1:05 p.m. that was unanswered. Another unanswered call was received at 1:06 p.m.
Yes.
The defense asked that the exhibit be not zoomed in and it's left to its original size, as under Rule 4.7, that's not permissible to enhance any image.
Response?
Your Honor, I have no problem zooming out for the exhibit.
Okay, sustained.
Detective, could you continue on what other CDRs that you found?
Yes, so in addition to the two previous unanswered call, a text message was received by Avery's phone at 1:17 p.m. All three of these communications went to cell tower 1197-1, which is the closest to Mr. Brockman's residence.
And in your expert opinion, what do the call detail records indicate?
It indicates that from 12:45 p.m. to 12:50 p.m., Avery Becker was most likely at home, and then she traveled along Rock Creek Parkway, and then from 1:05 to 1:17 p.m., Avery Becker was at Mr. Brockman's residence.
Your Honor, at this time, I move to enter the demonstrative as Exhibit 15B into evidence.
Any objection to 15B?
No objection, Your Honor.
15B is admitted.
Move to publish.
Granted.
And Detective, do you have an expert opinion on who killed Mackenzie Brockman?
Of course I do.
And before you give us that opinion, what factors did you rely upon on coming to this conclusion?
Well, I relied upon my training and certification as long as they called detail records.
Are these factors that others experts in your field would reasonably rely upon?
They are.
And Detective, what is that opinion?
So it is absolutely clear that Avery Becker broke into Mackenzie Brockman's home to burglarize and vandalize the property. However, Mr. Brockman then confronted Miss Becker, resulting in a scuffle. So then Miss Becker, my bad. Then Avery Becker. Okay, may I restart, Your Honor? I'm sorry.
Of course.
It is absolutely clear that Avery Becker broke into Mackenzie Brockman's home to burglarize and vandalize the property. However, Mr. Brockman then confronted Miss Becker. This resulted in both Mr. Brockman and Miss Becker in a scuffle that Avery Becker then fatally stabbed Mr. Brockman, leading to his death.
Thank you, Your Honor. No further questions at this time.
All right, cross-examination.
Yes, Your Honor. I would now like to discuss March 6, 2020 with you. In March, you were assigned to investigate the death of Mackenzie Brockman.
Yes, that's right.
You responded to the scene at 14:20 hours.
Yeah, so 2:20 p.m.
You observed the victim at the front door of his residence.
I did.
But didn't concern yourself with the body.
No, as the forensic team were doing their part.
So that's a yes, you didn't concern yourself with the body.
Yes.
You looked around the outside of the house.
I did.
And found a Ring doorbell.
That's right, as I stated in my testimony.
So that's a yes, you found a Ring doorbell.
Yes.
The doorbell is a part of the house's security system.
That's right.
A system with various cameras.
Yes.
The murder was recorded by the cameras.
No, as the homicide happened inside the property and the cameras were outside.
It is your sworn testimony here today that the murder was not found on the cameras?
The murder, I don't quite understand your question, Counselor.
The person, let me rephrase, the person who killed Mackenzie Brockman, can you see them on the cameras?
Oh, the murderer. I thought you said the murder. Yeah. Yes.
You found lots of mock trial related items at Brockman's house.
Yes, as well as in his phone.
But highly doubted it was related to his murder.
Yes, but as I believe I had to follow all the evidence.
Your Honor, permission to screen share Exhibit 10.
Granted.
Without going into its contents, could you please identify, permission to play the exhibit so that it can be identified, Your Honor.
Any objection?
Yes, Your Honor. As this has not been entered into evidence, it needs to be entered into evidence before we can see the video for the jury.
Can the jury see this? Counsel?
Your Honor, just because this is how, I'm so sorry. This is how the opposing counsel's been entering exhibits. I need to show the video so that it can be identified. I'm not trying
Very
to
good.
push it right now.
Very good. Go ahead.
So I'm gonna play. Now, based on that, I think we can identify it. Without going into its contents, is this a true and accurate copy of one of the Ring doorbell?
Yes, the one I saw.
Your Honor, we move to publish Exhibit 10 as its authenticity and accuracy have been proven.
Any objection?
No, Your Honor.
So I'll admit the exhibit and it can be published.
Okay. Now, based off of what you saw in Exhibit 10, that is the front door camera.
Yes, it is.
The murderer can be seen from there,
Yes.
and the murderer is completely covered from head to toe.
Yes, as I stated in my previous testimony, they are masked and hooded.
It's impossible to recognize the person in the video simply by seeing the video.
Indeed it is, unfortunately.
Every video of the camera shows the all the cameras and the videos that came from them, they show the murderer wearing the same clothes as seen in Exhibit 10.
Yes, that's right.
And none of them can identify who the murderer is.
No, they can't.
I would now like to talk about Mackenzie Brackman. He was a criminal defense lawyer.
Yes, he was.
One who you described as being a displeasure to work with.
Yes, I did state that.
Mackenzie Brackman may have been disliked by some of his clients.
He may have.
Clients he defended as their lawyer?
Yes, I believe so.
Some of which who were on trial for murder.
Objection, Your Honor. Relevance.
Relevance?
Your Honor, I've already laid the foundation that this witness has worked with Mackenzie Brackman in a professional capacity. So they're capable of knowing that. And it's super relevant, seeing as we're looking for who killed Mackenzie Brackman. And we need to look at other suspects as well. And this is a professional, so.
Reply from the people?
Your Honor, I see how the classification of his clients has nothing to do with this case under 401.
I'll overrule the objection. Go ahead.
Allow me to re-ask the question.
Yes.
Some of the people that Mackenzie Brackman defended were on trial for murder.
Yes, they were.
And some with violent histories.
I believe so, yes.
I would now like to talk about Alex Cifuentes. The first person you interviewed was Alex Cifuentes.
Yes, that's correct.
You built the rest of your case based off of what Alex told you.
As I follow all the evidence, it did lead me there.
But you did just base your case off of what Alex told you.
Not completely, as I found other supporting evidence, but I guess yes.
Without looking for other possible leads first.
Yes.
Alex told you about the text between them and another student.
Yes, that's right.
So you asked Alex to come to headquarters for a full interview.
I did.
Based on the text between Alex and the other student.
Yes.
Texts that were on his phone.
On her phone, yes.
Her phone, my apologies. Alex knew that you were going to interview her.
She did.
Objection, speculation.
Response?
Your Honor, the witness called Alex Cifuentes into an interview. If Alex didn't know that they were going for an interview after being called for an interview, I don't know.
Any reply?
Judge, I still don't see how the witness can actively know what Alex Cifuentes was thinking or knew at the time. So it's still speculation.
Objections overruled.
Alex knew you were interviewing him.
Yes, she did.
Alex knew you were curious about the messages.
She did.
Yet Alex failed to bring their phone to the interview.
Well, as some people get nervous when they are interviewed by police, so it's understandable.
But she did still fail to bring the phone.
She did.
And this is weird considering Alex is a high schooler.
It is, but like I stated, some people get nervous and they can forget things.
You've only seen screenshots of the exchange
Yes, I have.
and never saw Alex's physical phone.
No, I did not see her phone. Physically.
Nothing. Oh, I'm sorry. Continue. Nothing was done to verify the screenshots were confirmed to be authentic.
No,
And you have no proof that the images weren't manipulated with.
not that I know of.
I would now like to discuss the cell phone data recovery you pulled on Avery's phone. There's no way of knowing who was in possession of Avery's cell phone on March 6th.
No, there isn't, unfortunately.
Several calls were made to Avery's phone.
Yes, there
And
were.
some texts,
Yes, there were.
all from Taylor.
Yes, that's correct.
None were returned,
No,
and the calls were so short they indicate no reply.
no, as it was leading up to the time of Mr. Brockman's homicide.
Now, if you could please direct your attention to Exhibit 15. Your Honor, permission to screen share?
Yes.
Okay. Sorry, 1 second. Okay. You know what? You have access to Exhibit 15, right?
Yes,
Dr. Markowitz?
Foster.
Yeah. So looking at that, if Blair Rollins were to go to Markowitz, not to Markowitz, I'm sorry. If Blair Rollins were to go to Coach Brackman's house, would she take the same route as Avery was, or the same route that Avery's cell phone took?
Oh, this is outside the scope of my affidavit, but if you'd like me to answer, I can.
Yeah, well, I was just saying that in that same exhibit, allow me 1 second to pull up that exhibit. I'm sorry, I lost my, just 1 second. Okay. All right. Allow me to screen share now.
Very good.
Okay. Okay. Looking at Exhibit 15, can you identify where Blair Rollins' house is?
Yes, I can.
And this is it, correct?
Yes, that's right, as it's labeled.
If Blair Rollins were to go from her house to Brackman's house, would she take the same route as Avery Becker would have?
Your Honor, at this time, can I ask that the exhibit be put up to its full capacity and not zoomed in any form or fashion?
That seems to be a fair objection.
Your Honor, if you
Sustained.
look at the
Oh.
top of my screen, it's at 100%. It's not zoomed in.
Okay.
100% is the default. I can make it smaller if the defense would like, but I just didn't want to manipulate the image at all.
Okay.
Judge, please, if we can have the full exhibit so the jury is not misled by having only a partial exhibit.
Okay, let's make it a little bit smaller if we could, counsel.
Of course, Your Honor. Does that meet opposing counsel's satisfaction for the jury?
I still can't see the top of the exhibit, Counselor.
Okay. I'm sorry, let me.
That should suffice.
Okay, perfect. Well, that. Okay. So Blair Rollins would take the same route as Avery Becker would have.
Yes, they could have.
Okay. No further questions, Your Honor.
All right. Any redirect?
Yes, Your Honor. Detective, do you have any reason to suspect manipulation with the screenshots?
No, I don't.
And Detective, who was your most possible suspect in this case?
Well, following all the evidence, it led me to the most prime suspect, Avery Becker, in this.
Did you investigate any other leads in this case?
I did, but like I stated, most suspectful and our lead suspect is Avery Becker.
And what did you rely upon to come to that conclusion?
Well, I relied upon my training as well as the call detail records and text conversation between Avery Becker and Alex Fuentes to come to my conclusion.
No further questions, Your Honor. And barring any recross, I ask that my witness be excused from the stand.
Was there any recross?
No recross, Your Honor.
All right, the witness may step down. And we'll turn to the prosecution's second witness.
Your Honor, at this time, the prosecution would like to call Kyle Kuzak to the stand.
Very good. Go ahead.
Yes, Your Honor. Please state your name and spell the last for the record.
Kyle Kuzak, that's spelled K-U-Z-A-K.
And Mr. Kuzak, what is your employment?
I am a Colorado Bureau of Investigation certified crime scene reconstruction investigator, or if that's too much of a mouthful, CSR would suffice.
And Mr. Kuzak, how long have you been investigating crime scenes?
Let's see, I have 19 years of experience, with the most recent 3 being with the city of Denver.
And what does your job entail?
I investigate complex crime scenes, including home invasions, burglaries and other property crimes, domestic violence, homicides, fatal accidents, and armed robberies.
And what is your mindset going into a new investigation?
I have 2 key principles that guide my work. First, I believe that every case is going to trial, so I conducted a very thorough and a very comprehensive investigation. Second, starting from day 1, I memorialized, documented, and organized all events with a mindset of future reconstruction.
And how do you go about the actual investigation?
My investigation is through these 5 steps: recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, as well as reconstruction.
And is this methodology common practice among colleagues?
Yes, it is.
Your Honor, at this time, pursuant to Rule 702, I would like to enter Kyle Kuzak in as an expert in crime scene reconstruction to render his opinion in that area.
Any objection?
A brief voir dire, Your Honor.
Yes.
Mr. Kuzak, you provide no curriculum vitae to the court,
That is correct.
and you list no formal education in your testimony.
That is also correct.
You claim to use a 7-step method for event analysis. Can you tell the jury who invented this process?
I can't seem to recall. I'm sorry.
Your Honor,
Understood.
objection, facts not in evidence.
Response?
Could I ask opposing counsel to repeat the nature of the objection?
Yes.
Or I would like to change my objection to lack of foundation, I should say.
Response from defense?
Your Honor, I'm laying foundation as to what aspects of his work Kyle Kuzak should have a basic knowledge about.
Objections overruled.
Your Honor, we would have an objection to Kyle Kuzak being entered as an expert, seeing as he has displayed a lack of knowledge about his own processes.
Any response?
Your Honor, pursuant to Rule 702, he has well enough experience with this process, and we only have to prove one of the three things of experience, training, experience, training, and or education, and he has well enough experience.
All right, the objection's overruled. The witness will be admitted as an expert.
Yes, Your Honor. Mr. Kuzak, why are you here today?
I am here today to testify to my findings at the scene of the homicide of Mackenzie Brackman at 444 South Flower Street. I conducted that methodology in this case that I talked about earlier.
And what kind of conclusions did you come to after completing your methodology?
After completing all of the methodology, I came to the conclusion that the defendant matched the same.
Objection, Your Honor. Lack of foundation.
Response?
Your Honor, I believe that the witness has talked about his 5-step methodology, along with he is just talking about what he did and what kind of conclusions he came to after completing that methodology.
Response, Your Honor.
Yes.
The witness has spoken nothing as to his investigation into this case in particular, and is jumping straight into his conclusion.
Perhaps we could have a little bit more background for the conclusions. Prosecution?
Yes, Your Honor. I will lay more foundation.
Very good.
How did you, or what is the first bit of evidence that you came upon when going into this investigation?
The first bit of evidence was the body the body at the homicide.
And
I'm going to reverse my ruling and allow you to go into the conclusions and draw some foundation as part of that, perhaps. Okay, so I'll go back to that original question you had.
yes, Your Honor. What led you to your conclusions of after completing your methodology?
All of the evidence that was found at the scene of the homicide led me to my conclusions.
And what were those conclusions?
That the defendant matched the same height and build of the perpetrator that entered Mr. Brackman's home and checked the front porch and checked that door.
And where did the perpetrator go next on these ring videos?
They then proceeded to the south side of the residence, where they opened the fence gate into the backyard and then entered the residence through the back sliding glass door.
And Mr. Kuzak, do you believe the victim was alerted of the perpetrator?
Yes, I believe the victim was alerted by his ring video security.
And why do you believe he was alerted?
Because I believe that the victim went and looked for a knife in self-defense.
And moving on, was there anything left near the back door?
Yes, there were scuff marks on the floor.
Your Honor, may I show the witness what has been marked as Exhibit 18?
Yes.
Do you recognize this image?
Yes.
And what is this image?
This is a picture of the scuff marks found near the back sliding glass door.
And is this a fair and accurate representation of those scuff marks you saw that day?
Yes, it is.
Your Honor, I move to admit Exhibit 18 into evidence.
Any objection to 18?
No objection, Your Honor.
18's admitted.
Your Honor, I would also move to publish to jury.
Granted.
Mr. Kuzak, what is your opinion on these scuff marks?
Objection, Your Honor. Under Rule 702, scuff mark analysis has not been laid out as a portion of this witness's expertise.
Your Honor, if I may, I believe that this is, after many years, 19 years of experience to be exact, I believe that this would be a common thing seen at crime scenes, scuff marks in crime scene reconstruction.
So I'll overrule the objection and start to hear the testimony, and I can revisit it if necessary.
Yes, Your Honor. Would you like me to repeat my question, Mr. Cusack?
Yes, please.
What is your opinion on these scuff marks?
These scuff marks indicated that a struggle took place between the two individuals, moving from the back door to the kitchen table.
And did you notice anything else in the kitchen?
Yes, there was also a open knife drawer as well as a knife block on the counter with one knife missing.
And is Exhibit 7 that same knife drawer?
Yes, it is.
Did anything else indicate a struggle?
There was also a broken plate near the kitchen table 5 feet from the back door. This also indicates that the struggle moved from the back door to the kitchen table.
And is Exhibit 9 that Jordan Markowitz introduced that same broken plate?
Yes, it is.
And what do you believe happened next?
There was a series of blood droplets that led from the kitchen to the front door. That is also where the body and the knife, which I believe to be from that knife block, were both discovered.
And what was around the body and knife?
There was a cast-off blood splatter on the ceiling and walls. That's consistent with the theory of the victim pulling the knife out himself.
And why do you believe this homicide happened?
This was clearly a planned burglary gone wrong. The perpetrator would have chosen a time when the victim would have not been home. Unfortunately, that was not the case, in which the two individuals ensued in a struggle, leading to Mr. Brackman being killed.
Finally, Mr. Cusack, do you believe that this is the only conclusion for the events that happened on March 6, 2020?
Yes, the conclusions that I've expressed are based on sufficient facts and data. They are a product of reliable principles and methods. This is the only possible outcome for the events that occurred that day.
No further questions at this time. Yes, at this time, Your Honor.
All right, cross-examination.
Yes, Your Honor. Mr. Cusack, you visited the crime scene
Yes,
after it was processed
that is correct.
by the official crime lab.
That's correct, yes.
And you make no mention of ever interacting with any tangible evidence in court today.
That is correct.
Only photographs, audio, and video.
That's correct.
All of these given to you by the police department.
Yes.
Your Honor, permission to screen share Exhibit 17.
Yes.
Kyle Cusack, this is a copy of your witness information tracking sheet
Yes, it is.
and your evidence tracking sheet
Yes.
and your flow chart.
Yes.
And it's an accurate copy.
Yes, it is.
Your Honor, we offer Exhibit 17 into evidence as its accuracy has been testified to.
Any objection to 17?
Yes, Your Honor. I object to this document being hearsay.
Response?
Your Honor, one moment to confer with the evidence.
Okay.
Permission to stop sharing.
Granted.
Your Honor, this is an exception to hearsay under Rule 803.5 or 803.6, as it is a record of a regularly conducted activity, being Kyle Cusack's police investigation.
Response from the people.
Yes, Your Honor. I don't believe there's been enough foundation laid for this to be a regularly conducted activity.
Your Honor, response?
Yes.
I believe that in direct, Kyle Cusack testified that this sort of organizational formatting is common in his work.
All right, the objection's overruled. The exhibit is admitted.
Your Honor, at this time, I would also like to object to cumulative.
Brief response to the cumulative objection.
While there is some aspects of this exhibit that the witness has testified to, there are many other aspects that the witness has not testified to.
Objections overruled.
Permission to resume screen sharing.
Granted.
And permission to publish to the jury.
Granted.
Mr. Kuzak, you created all aspects of this exhibit. I'd like to direct the jury's attention to the first page. A piece of evidence was gathered from Avery Becker.
That is correct.
You labeled this as evidence number 1140.
Yes, I did.
You incorporated this into your organizational framework,
Yes.
and it influenced your conclusions.
Yes.
It's not available to the jury today.
That's correct.
And you recorded no details other than the source about the exhibit. Evidence, I mean.
That is correct.
You even include potentially fallible evidence in this framework.
That's correct.
On the first page, you include 3 possible suspects.
Yes.
One is Avery Becker, of course.
Objection, Your Honor. Cumulative.
Overruled.
Mr. Kuzak, one suspect is listed as Avery Becker,
Yes.
but you also list Cifuentes as a suspect.
Yes, I did.
Now I'd like to direct the jury's attention to the third page. You created this flowchart.
Yes, I did.
In the first of 5 steps to efficient CSR work,
Yes,
before evaluating the evidence.
that's correct.
Now I'd like to discuss the perpetrator that we saw earlier in the ring videos. Is that all right?
That's all right.
The person in that video is wearing a mask
They are.
and a jacket
Yes.
and gloves.
Yes.
And the perpetrator's DNA was not found at the crime scene.
That is correct.
Neither were fingerprints.
That is also correct.
Now you believe that the knife used for the murder weapon came out of that knife block, as you testified to on direct.
That's correct.
But the police make no mention of ever trying to confirm whether that knife came from that knife block.
That's correct.
For example, they don't even see if it fits.
Yes.
Now I'd like to go back to addressing the investigation as a whole. Do you understand?
Yeah.
Actually, Your Honor, I'm sorry. Permission to stop screen sharing.
Granted.
You say this seemed like a straightforward home invasion.
Yes.
But you were not able to recreate all event segments.
That's correct.
Your conclusion does not account for all the evidence.
That's correct.
No further questions, Your Honor.
Any redirect?
Yes, very brief, Your Honor.
All right.
If you list somebody as a suspect, does that mean they're guilty?
No, it does not.
And moving on. And do you need DNA evidence to convict somebody of murder?
No, you do not.
No further questions at this time, Your Honor. And I ask, barring no recross, that my witness is able to step off the stand.
Any recross?
No, Your Honor.
All right, the witness may step down. Thank you. We'll turn to the third witness for the prosecution.
Your Honor, the defense calls Alex Cifuentes to the stand.
All right.
And may I have a brief time check from the timekeepers?
Let's do that.
Okay. All right. Please state your name and spell it for the record.
My name is Alex Cifuentes. That's Sifuentes.
And Ms. Cifuentes, why are you here today?
I'm here today because something really terrible happened to my mock trial coach, and I'm just trying to be any help I can.
How were you introduced to mock trial?
My freshman year, Avery introduced me to the team, and since then I've been pretty passionate about it.
And how do you know Avery Becker?
Me and Avery used to be really close. She was actually my best friend.
If I asked you to point out the defendant in the courtroom, could you?
Yes, absolutely.
Your Honor, I ask that Avery Becker turn on her camera to be identified.
All right, granted.
Would you please describe for me the defendant here today?
Avery has brown hair that's pulled back right now and a tan colored top.
And how do you know that that is her?
Well, of course that's Avery. I've gone to school with her since my freshman year, and I wouldn't have done mock trial if it wasn't for her.
Has your relationship with Avery changed since freshman year?
I guess you could say our relationship has become more strained in a sense. During our last season of competition, Avery kind of lost the team player mentality that the rest of us had and would show up to practice late and blatantly disrespect our coach.
You mentioned that Avery disrespected Coach Brackman. Why is that?
I thought Mr. Brackman was an amazing coach. He always pushed all of us to our full potential, especially Avery, and I really looked up to him.
You mentioned that Brackman would reprimand Avery for her behavior. What effect did this have on the relationship between Avery and Mr. Becker, or Avery and Mr. Brackman?
Objection, this calls for speculation.
Response?
Your Honor, as this goes towards my witness's rationally based perception, I believe that her time on the team and her time spent with Miss Avery Becker and Mr. Brackman, she can testify to this knowledge.
Reply?
Your Honor, this is outside of the witness's rationally based perception because she cannot testify to the specific relationship that Avery Becker had with her coach, regardless of how close in contact she came with both of them.
Objections overruled.
You mentioned that Mr. Brackman would reprimand Avery for her behavior. What effect did this have on the relationship between Avery and Mr. Brackman?
Avery hated Mr. Brackman for constantly getting on her about her work ethic, and I would say that the two have always had a bit of bad blood.
How did Avery respond to Mr. Brackman's critiques?
Avery frequently refused to do as asked of her and try to play the victim sometimes. There was one time, which I consider the boiling point of the relationship, where Mr. Brackman had confronted Avery and she acted pretty irrational, if you ask me.
What was this boiling point?
Avery had come into practice late like usual, and towards the end of practice, Brackman had demoted her to B team.
What happened after Avery got demoted?
After being demoted, Avery convinced her friend, Taylor Perkins, to quit the team as well.
And after Perkins quit?
This forced Mr. Brackman to put Avery back on A team because he really had no other choice for us to do well during our competition.
And what happened after your regional competition?
Coach Brackman was really upset with Avery, and after a conversation the two had after regionals, it seemed like Avery was pretty upset, and on her way out off of campus, she did something that I don't think anybody would have expected.
What did she do?
She wrote on Mr. Brackman's car with a permanent marker.
What happened when Mr. Brackman found out?
Mr. Brackman kicked Avery off the team, which once again left us in a state of panic where we would have to forfeit due to the rules at state because last-minute substitutions couldn't be made.
I'd now like to talk about the text messages between you and Avery. What was this conversation about?
Well, Avery had been trying to convince Mr.
Objection, Your Honor. I would ask that opposing counsel please share the screenshots while they are talking about them so the jury and the rest of the court can view them as well.
Response?
Permission to screen share, Your Honor.
Granted.
Okay. Ms. Cifuentes, what was this conversation about?
It was Avery texting me to try to talk to Mr. Brackman to get her back on the team after her position had been terminated.
Your response?
Looks like we're out of time. And So we'll have to move to cross-examination, I believe.
Yes, Your Honor. Hello, Ms. Fuentes. In your statement, you say that throughout your time on the team, Mr. Brackman wasn't happy with Avery for her lack of preparation.
Yeah, Mr. Brackman would get upset with Avery frequently because
Thank you. You've answered my question. My question was about your statement.
Objection, Your Honor. I ask that my witness be allowed to respond fully to the question asked to her, especially if it calls for more than a yes or no response, as this did.
May I respond, Your Honor?
Yes.
This particular question did not ask for anything but a yes or no response, as I was asking the witness about what she said in her statement specifically.
Can you restate your question, counsel?
Yes, Your Honor. In your statement, you say that throughout your time on the team, Mr. Brackman wasn't happy with Avery for her lack of preparation.
The objection is overruled, and so the one-word answer is fine.
All right. You, however, prepared furiously for mock trial competitions.
Of course I did.
You claim, however, in your statement that despite this difference in preparation, you and Avery were of the same skill level.
Yes, Avery had also been in mock trial for a year longer than me, so that adds up.
And despite being similarly skilled, however, you agree with Mr. Brackman's decision to demote Avery to B team.
Yes, I did. I thought that her lack of preparation put our team in jeopardy. So I did agree to that merely for the sake of the team in general.
Thank you. In your statement, however, you also go as far to claim that Avery won awards based on looks alone.
I did say that, yes.
All right, let's move a little further down the timeline. You were there on the day that Avery drew on your coach's car.
Yes, I was. It was at our competition.
And Mr. Brackman would not let Avery back on the team after that, is that correct?
No, and I'm surprised he didn't press charges on her because that was vandalism.
So personally, you believe that Avery should have been hit with criminal charges for that accident?
Oh, absolutely. Anybody that vandalizes something should be hit with criminal charges.
Despite this, you claim in your statement that you and Avery were best friends.
We were, but that doesn't mean I support criminal activity for anybody.
That's a yes. You claim you and Avery were best friends.
Yes.
Moving along. A few weeks ago, someone you believe to be a private investigator came to you.
Yes.
And you refused to speak to her.
Yes, I thought in this specific scenario where my coach had actually passed away, I knew who they were and I knew that they weren't looking for the truth, but rather an alternative timeline. So no, I did not speak to them and I had the right to not speak to them.
All right, so that's a yes, you refused to speak to her?
Yes, as I said at the beginning of my statement.
I'm clarifying. And despite having information, correct?
Yes.
You found out that you were being accused of stealing Avery's phone.
No, I actually was given Avery's phone to play a game on.
I'm sorry, that was not my question. I must have confused you. You found out you were being accused of stealing Avery's phone.
I found out I was being accused.
Thank you. That was my question. And you were also being accused of giving it to Blair Rollins.
Accused, but there's no grounds for these accusations at all whatsoever. So I'm not stating them as if they're a fact.
That's a yes. You found out you were being accused.
Accused, yes.
Thank you. So you were accused of giving it to Blair Rollins, who you went to school with. Is that correct?
Yes, but anybody could accuse anybody of anything if there's no grounds for evidence. I'm not sure why you're bringing it up.
You would claim, though, that you'd never do that. Is that correct?
Oh, absolutely not. As I said, I don't condone criminal activity and I wouldn't do it myself.
In fact, in your statement, you claim you wouldn't do that because it would put Mr. Brackman in danger.
Absolutely.
So you believe that giving the phone to Blair Rollins could have put your coach in danger?
I suppose in a situation it could.
That's a yes. Giving the phone to Blair Rollins would put Mr. Brackman in danger.
Possibly.
Objection, Your Honor.
I'm sorry.
The attorney is badgering my witness.
May I respond, Your Honor?
Yes.
I'm asking for a yes or no answer on this specific question and asking the witness to clarify. I am no way badgering the witness.
Objections. Go ahead.
As my witness has constantly been testifying and this attorney has been cutting her off and yelling over her, I believe that she is badgering my witness and not allowing her to respond.
May I
Objections,
reply?
objections overruled. Got about 20 seconds left.
So, Ms. Fuentes, yes or no?
you believe that giving the phone to Blair Rollins could put your coach in danger.
As I said, it's a possibility.
So that's a yes.
No, it's a possibility. There's no actual grounds. It could have not. So it's a maybe. It didn't happen, so I couldn't tell you.
Thank you. We're out of time.
All right, we're out of time for the prosecution's case. Shall we turn to the defense case and turn to the first witness?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
All right. You may proceed.
Please state your name and spell your last for the record.
Professor Blake Van Owen, V-A-N-O-W-E-N.
And Professor Van Owen, what do you do for a living?
I previously worked for the Aurora Police Department, but I'm now a private investigator, a professor, and I've consulted on more than 100 cases.
And what is your educational history?
I have a master's degree in criminal science through Ashford University. I've taught a course on police procedures at the Community College of the Rockies, and I've taught a course at CU Denver on police practices and social justice.
And are you familiar with courtroom proceedings?
Yes, I've testified as an expert witness regularly before in the areas of police practices, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
And how long have you been in this line of work?
I've been teaching for over 5 years. In the average year, I'll handle between 9 and 12 cases similar to this one in terms of my time commitments.
During an investigation, how do you form your opinions about a case?
As I've said in my expert report of this, I review the police reports and investigation by the prosecution. All of my opinions are offered to a degree of reasonable scientific certainty based on my training, experience, and expertise.
Your Honor, I move to admit for Professor Van Owen as an expert witness in crime scene investigation, cell tower analysis, general police investigation tactics, and forensic evidence techniques, as her experience and education qualifies her to give an expert opinion under Rule 702.
Any objection?
Brief voir dire.
Yes.
Previously, you worked at the Aurora Police Department,
Yes, for about 9 months.
but later you quit your job.
Yes.
And you have not worked under a police department since.
No.
As you stated, you left only after 9 months of working experience.
Yes, there was an incident.
And you haven't worked at the in a police department in 8 years.
Yes.
Or been recertified in their most current practices.
No.
And you are unaware of all of the procedures that have been put into place since you left.
I testify regularly as a defense expert. I am aware.
But you have not worked under a police department since 8 years ago?
No.
And are testifying to their procedures today with only the 9 months of experience that you had previously working with them?
Yes, I suppose so.
Your Honor, I object to this witness being entered as an expert witness under police practices due to their lack of training.
Response?
Your Honor, under Rule 702, an expert may be qualified by experience or education. And as Ms. Blake Van Owen has just testified to, she does have experience not only testifying, but also operating in the police field.
The objection is overruled. The witness will be admitted as an expert in those areas.
I'm going to start by asking you about this case in general. What is your connection to this case?
I was hired by the Becker family as a private investigator.
And are you familiar with the way the police conducted this investigation?
Yes.
And in your professional opinion, was the investigation thorough?
No, absolutely not. This investigation was rushed.
Do you know any of the prosecution witnesses in this case?
I professionally know Kyle Kuzak, and I've been in more than one case handled by Detective Markowitz.
And do you see Kuzak here today?
Yes, Kyle testified earlier and is sitting with the other prosecution witnesses.
Are you familiar with his conclusions?
Yes, I've reviewed the conclusions thoroughly.
Based on your expert evaluation, do you agree with his conclusions?
No.
Why not?
It's clear to me that Detective Markowitz influenced Kuzak's findings. Kuzak's entire report is based on assumptions, such as how the murder happened or where the knife came from, along with misleading cell tower evidence.
Are you familiar with the evidence gathered by the police in this case?
Yes, I am.
You mentioned earlier a knife. Can you tell the jury about the relevance of the knife?
Kuzak saw a knife block missing a knife and a knife wound and made the assumption that the two were connected. If he had looked more closely, he would have seen that the knife brand and size is inconsistent with those in the block and the knives in the drawer from Exhibit 7. It's just as likely that the murderer brought the weapon on scene.
You also mentioned that you disagree with Kuzak on the issue of how the victim was stabbed. Can you explain those inconsistencies as you see them?
For Kuzak's theory to work, the intruder would have to be much bigger than the victim. But for ring video evidence, that's not true. A much more logical explanation would be that the intruder stabbed Brackman in the back while he was seated. This theory lines up with the autopsy report as well.
You also mentioned cell tower evidence. Let's move on to talking about that. Are you familiar with the cell tower records?
Yes.
And what do those records indicate?
To put it in simple terms, even a layman or Detective Markowitz can understand, cell towers aren't like a GPS. In an urban environment, you could make 5 separate calls while being in the same spot, but each of those calls connect to a different tower.
In your professional opinion, are those cell tower records accurate?
No. The only information the police have that physically links Avery Becker to the crime scene is that the lost phone connected to the closest tower, which is definitely not the same thing as Avery actually being at the house. Taylor's phone was pinged at the mall in Fry Shack, and this also supports Avery's alibi.
Is this the only cell phone evidence that you've reviewed?
No, I've also reviewed text message screenshots from Alex Cifuentes' phone.
And what can you tell us about those screenshots?
They're only that, screenshots. The police have the technology to download contents of smartphones. The police did no such thing, and so we can't trust that Alex Cifuentes didn't tamper with them. I take everything with a gallon of salt.
In your statement, you mention a Blair Rollins. Who's Blair Rollins?
Blair is Avery's fellow Colorado high school student.
And what is her connection to this case?
Well, in addition to the fact that she attended the same high school as Avery, Blair's father was represented by the victim, Mackenzie Brackman, in court. In fact, I investigated Blair as an alternate suspect.
Why did you suspect Blair?
She has the same height and build as Avery, and no face is shown in the ring videos. Blair was also absent from school on the day of the murder and holds a much stronger motive.
What do you mean by a much stronger motive?
Blair's father, Jonathan Rollins, was found guilty of murder and sentenced to life in prison. Mackenzie Brackman, the victim, was Mr. Rollins' attorney and lost the case. You know, opposing counsel says revenge is a powerful motive. Certainly, your father going to jail for murder is a much more powerful motive than being kicked off the mock trial team.
Your Honor, permission to screen share Exhibit 22.
Granted.
And as it is an audio recording, permission to play it once.
Any objection?
No, Your Honor.
Granted.
I'll get you back, Brackman, if it's the last thing I do.
Have you heard Exhibit 22 before?
Yes, it was part of my investigation.
Without going into its contents, please identify it.
This is a tape from Jonathan Rollins' court hearing.
Is it accurate?
Yes.
Is it authentic?
Yes.
Your Honor, I move to admit Exhibit 22 into evidence as its authenticity and accuracy have been shown.
Any objection to 22?
No, Your Honor.
22 is admitted.
And permission to publish to the jury.
Granted.
And permission to stop screen sharing.
Granted.
Professor Van Owen, what's happening on this tape?
After the sentencing with Blair in the audience, Jonathan Rollins threatened to get even with Brockman.
And why is that relevant?
As you just heard, Blair Rollins has a much stronger motive to kill the victim. Her father was sentenced to life in prison because of the victim.
Moving on. In your professional opinion, does this investigation establish the prosecution's theory beyond a reasonable doubt?
No, the prosecution's case rests entirely on assumption after assumption, inconsistency after inconsistency. Avery has a solid alibi. Their investigation—
Objection, Your Honor, ultimate issue.
Response?
May I ask the defense to the prosecution to clarify what specifically they're objecting to?
Okay.
Your Honor, as this witness has testified that she said beyond a reasonable doubt, that is a condition of the charges, therefore leans towards the ultimate issue, which she is not allowed to address. 704B.
May I respond, Your Honor?
Yes.
Beyond a reasonable doubt is not a condition of the sentencing or anything close to that. It is merely the burden of the prosecution.
All right, objections overruled.
Would you like me to re-ask the question?
No, I remember. Avery has a solid alibi. The prosecution's case was entirely rushed and incomplete. Their investigation doesn't come close to meeting a burden of proof.
Thank you, Your Honor. No further questions.
All right, cross-examination.
Yes, Your Honor. Your work experience started at the Aurora Police Department.
With law enforcement, yes.
This job led to an incident on duty concerning police practices.
Yes.
Police practices that, in your opinion, were highly inappropriate.
Yes.
This same incident led you to quit your job at the department.
Yes.
And left you with an enduring disdain for police procedures.
Yes.
This disdain for police procedures has led you to your current job as a crime scene reconstructionist.
It has led me to my job as a private investigator and defense expert.
This disdain for police practices has also led you to be an adversary of the police practices as you are here today.
Yes.
And you are being paid in this case to develop an alternate theory of events of what happened at Mr. Brackman's house on March 6th.
I'm paid for my time, not my opinion.
In fact, you say that you make a pretty good living revealing where the police dropped the ball.
I do, and the police dropped the ball a lot.
You not only reviewed the evidence in this case, but conducted your own partial investigation.
Yes.
And that partial investigation suggests that Brackman didn't receive a ring notification when the intruder approached his door.
Yes, and mind you, that is the first step for Cusack's theory of the bear hug.
And that partial investigation suggested that a physical altercation didn't occur.
Yes.
And that partial investigation suggests that Mr. Brackman was seated when he was stabbed.
It does.
And that partial investigation suggests that Avery Becker's phone did not connect to the nearest cell tower.
Yes.
I have just a few more questions for you regarding your partial investigation. During your direct, you offered Blair Rollins as an alternate suspect.
I do.
And you've never met Blair Rollins?
No, funny enough, it has come to my attention that Blair seemingly left the state after graduation.
Then you don't know what motivates Blair Rollins.
I have a theory.
And so regarding the recording of Jonathan Rollins, Blair's father, Exhibit 22, you would agree with me that accurate representation or accurate information be reported?
Yes, that tape was accurate.
You submitted a sworn and signed statement for this case.
Yes.
And you stated in this statement that Jonathan Rollins yelled out when being escorted back to jail that Brackman was going to die.
No.
It is your testimony today that you did not state in your affidavit that that when Jonathan Rollins was being escorted back to jail, that Brackman was going to die?
Jonathan said he was going to get Brackman back if it was the last thing he ever did.
Your Honor, permission to show this witness her own affidavit.
Granted.
One moment, co-counsel is pulling up the affidavit.
Very good.
Is this your affidavit?
Yes,
And at the end of this affidavit, is that your signature?
it is.
Now, would you please read along with me on line 256, or 255 through 256. After the sentencing, as he was being escorted back to jail, Jonathan Rollins yelled out that Brackman was going to die.
That is what I said.
Thank you, co-counsel. You can now take down the affidavit. So again, and you stated that statement, Jonathan Rollins, and then you stated that Exhibit 22 was a recording of this statement.
Yes,
And isn't this an example of the police investigative practices that you have spent your life's work fighting against?
I don't understand the question you're asking, Counselor.
That this misrepresentation of facts is an example of police investigation practices that you've spent your life's work fighting against.
It certainly implied that Jonathan Rollins meant he was going to kill Brackman.
And is yet another fact suggested in your partially conducted investigation.
Yes, it's another fact I suggest.
Thank you, Your Honor. No further questioning.
Any redirect?
Yes, Your Honor. Professor Van Owen, what does Exhibit 22 state?
Exhibit 22 states that Jonathan Rollins threatened to get even with Mr. Brackman, the victim.
And why do you, in your professional opinion, believe that's relevant to this case?
Blair Rollins was Jonathan Rollins' kid. She has a much stronger motive to kill the victim. Her father was sentenced to jail for life.
Thank you, Your Honor. No further questions.
Any recross?
No, Your Honor.
All right, thank you. The witness may step down. We'll turn to defense witness sec 2.
Your Honor, the defense calls Taylor Perkins to the stand.
All right. You may proceed.
Good evening, Ms. Perkins. Could you please state your name and spell your last for the record?
Yes, Taylor Perkins, Perkins.
What are your pronouns?
She, her.
And what is your connection to the case here today?
I was a senior at Colorado High School with Avery Becker, my best friend. Avery and I had a good connection and we really understood each other.
Well, can you elaborate on that connection to the case?
I was on the Colorado High School mock trial team with Avery and Mackenzie Brackman as our coach.
I would now like to discuss the mock trial team with you. What kind of a teammate was Avery?
Avery was never really prepared, but she didn't have to be. Avery was still the best teammate and the best lawyer on the team.
What were the relationships like with Avery and the rest of the team?
Objection, Your Honor. Relevance.
Response?
I'm laying foundation, Your Honor.
Okay,
Your Honor, if I may,
yes.
I don't see why Avery's connection to anybody on the mock trial team has to go toward or has to do with this being a murder trial.
Any response?
Your Honor, this line of questioning that I'm going down will explain the connection that Ms. Perkins has here to the case and her connection to Avery and how that all plays in. I just need to ask this series of questions to be able to lay that foundation.
All right, I'll give counsel some leeway. Objections overruled.
Yes, Your Honor.
Would you like me to re-ask the question?
Yes, please.
What were the relationships like with Avery and the rest of the team?
Well, Avery didn't necessarily get along with the rest of the team, specifically Alex Cifuentes and Coach Brackman, but Avery never seemed too serious about it. She always meant well, and it was just pranks anyway.
How did Avery feel after any scuffles with the team?
Avery would feel so bad. I mean, I could just tell how remorseful she felt after anything happened.
Objection, Your Honor. Speculation.
Response?
Your Honor, we've established that Taylor Perkins is Avery's best friend, and she's discussing the physical features that were noticeable that could see that remorse, and coming from both a best friend that admitted that she knows Avery like the back of her hand, and what's actually like coming out, it's rationally based off of the witness's perception.
Any reply?
Your Honor, I don't believe during the witness's testimony did she ever bring up any physical description like co-counsel or like opposing counsel just brought up.
Objections overruled. I'll allow you to explore that on cross.
Would you like me to re-ask the question, Ms. Perkins?
No, that's okay. One time that stuck out to me about her feeling bad after anything was after the car incident after regionals. She told me how much she regretted doing it, and it was really clear that she really meant that.
I would now like to discuss Thursday, March 5th, 2020. What happened on that Thursday?
After she'd been kicked off the team, Avery showed up to mock trial practice to try and talk it through with Coach, but she was told to leave. Avery then came to my house where we hung out for a while and played games on our phones. Later, we went to the Fry Shack to get something to eat, but that showed out to be a bad choice.
Why was the Fry Shack a bad choice?
Shortly after we got to the Fry Shack, the majority of the mock trial team showed up, and they came in after practice.
Did you interact with the team at all?
Yeah, everyone on the team was telling Avery how unfair it was that Coach.
Hearsay.
Response? Hearsay objection?
I'm a little bit confused. If opposing counsel could just explain what's hearsay.
Your Honor, I believe that the witness stated everybody was telling Avery, which implies that it's a statement made outside of this court today.
Your Honor, response?
Yes.
Avery and Taylor Perkins were sitting at a table together, interacting with the team together. They were talking to Avery, but Ms. Perkins was there listening to the entire conversation.
Objections overruled. Go ahead.
Did you interact with the team at all, Ms. Perkins?
Yeah, everybody was telling Avery how unfair it was that Coach kicked Avery off the team, even Alex Cifuentes. Avery got kind of upset and stormed off to the bathroom. Her phone was still on the table, though, which really showed how upset she was.
I'd now like to discuss the specifics of March 6, 2020. Do you know where Avery was on March 6th?
She was with me the entire day. She had lost her phone the day before, so we spent the day looking for it.
What happened that morning?
Avery picked me up at my house. She hadn't answered any of my texts all morning, and so when I brought it up, we realized that Avery's phone was missing.
What happened next?
We decided to go look for it. We didn't really have to be at school that day, so we went to search for her phone instead. We retraced all of our steps. I called and texted her phone the entire time, but we had no luck finding it.
After Avery picked you up, where did you go?
We first went to the mall and we searched every store we had gone in the day before. We didn't find it, and that's when I remembered Avery leaving her phone on the table at the Fry Shack the day before. So we went there next.
How long did you and Avery spend looking for the phone?
We burned all day. We spent most of it at the mall, and then we went to the Fry Shack where the afternoon shift staff helped us look.
Did anything stand out to you about the Fry Shack?
Well, not at the moment, but reflecting back to why I'm at the stand in the first place, yeah.
What did you realize? Well, what did you notice?
Well, the mock trial team showed up while we were there looking for her phone.
And why did this stand out to you?
Because they were supposed to be at mock trial practice, but apparently Brackman never showed up, so they left after 15 minutes. It's really weird now to think that Brackman was bleeding out while we were talking about him.
I'd now like to ask you some questions about Blair Rollins. Who is Blair Rollins?
Blair was also a senior at the Colorado High School.
Do you know Blair Rollins?
Yes, I know Blair by her reputation.
What kind of reputation is that?
Objection, Your Honor. Improper character evidence.
Response?
Your Honor, I'm laying some foundation on this character, and this asking these questions are relevant to our contention that there was an alternate suspect, and that's admissible under 405A because the rule states that providing evidence of a person's character by testimony and reputation is admissible. About reputation is admissible.
Reply?
Your Honor, under Rule 403, the court may exclude relative evidence if probative value is substantially overweighed by danger of one or more of the following: unfair prejudice, and I believe that is unfair prejudice right there.
Your Honor, response?
Very brief.
The objection wasn't relevant, so we can't, and yeah, the objection wasn't relevant.
The objection's overruled.
What kind of reputation do you know about Blair Rollins?
Well, Blair kind of had a thing with Brackman. Brackman was her dad's lawyer in a case a while ago, but Brackman lost the case and sent Blair's dad to prison. Everybody kind of blamed Coach for that, and since then, it's been an issue between Blair and Brackman.
What is Blair's friend group?
I'm not entirely sure exactly who Blair hangs out with.
Honor relevance.
Response?
Your Honor, I established at the beginning of this line of questioning that I'd be asking some questions about Blair Rollins, so it's very relevant to this line of questioning.
Your Honor, if I may, I don't see how somebody's friend group in high school has to do with this murder that occurred.
Well, let's see where this goes. I'll give counsel some leeway. Objections overruled.
Yes, Your Honor.
What is Blair's friend group?
I'm not entirely sure exactly who Blair hangs out with, but I do know that Alex is pretty close with Blair.
What is Blair's body build like?
It's almost identical to Avery's build, actually. They look very similar.
I just have some final wrap-up questions. Based on your knowledge of Avery, is Avery capable of this?
Look, Avery could be rash or have an inflated ego at times, but Avery was definitely not irrational enough to commit murder. And she definitely couldn't have committed this one because Avery wasn't there. We were looking everywhere for her phone.
Would you lie for a friend?
Absolutely not. And it doesn't even matter what I'm saying because there's proof that I'm telling the truth. There were plenty of people at the mall, and the afternoon shift saw us at Fry Shack too.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Miss Perkins, you're here to testify for your best friend, Avery Becker.
Yes, I am.
And she was the only reason why you were in mock trial.
Yes.
And when she got demoted from A team to B team, you quit.
Yes, I did. She deserved the spot more than me.
And you quit so she would get that spot.
Yes, I did.
Because you would do anything for her.
Almost anything.
And later on, Avery and Brackman had gotten into a fight after this.
Yes.
A fight that led to Avery riding on Mr. Brackman's car.
Eventually, yeah.
And you found this unfair, or she got kicked off, sorry. She got kicked off the team for this incident,
Yes, she did.
and you found this unfair,
I did. The whole team found it unfair.
and this led to you guys trying to find ways for her to get back on the team.
Yeah. Avery originally was trying everything.
And she texted everyone,
Yes, she did.
including Alex Cifuentes.
Yes.
And neither of you guys liked Alex Cifuentes.
No, not necessarily.
Later, Avery made one last effort to get back onto the team with Mr. Brackman.
Yes, she did.
And after getting rejected, she came to your house?
Yes, we hung out there. She always came to my house for anything, so.
And later you guys went to the Fry Shack,
Yes, we did.
where you saw mock trial kids.
Yes.
And even Alex was there.
Yes.
And Avery got upset, so she stormed off.
Yes, she did.
And after storming off, you admit that you wanted to punch Alex in the face.
Yeah, it was a heat of the moment.
So that's a yes.
Yes.
And when she came back, you guys decided to leave.
Yes, we did.
And Avery happened to leave her phone at the Fry Shack.
Yes, but I didn't really realize it until the next morning.
And you refer to Avery's phone as a third kidney, correct?
Yes.
So you believe Avery left her third kidney on a table.
Yeah. She was really mad at that moment, and yeah.
But she left her third kidney on a table.
As I said, yes.
Objection. Oh, I was going to do asked and answered. I just asked that if my witness answers a question.
Sustained.
Yeah, Your Honor, if I may, I was just restating the question as opposing counsel has done in this same trial. I was just trying to get the yes or no that I was looking for. And at this time, no.
Okay, very good. All right. Any redirect?
Yeah, briefly, Your Honor.
Okay.
Miss Perkins, where was Avery on March 6th?
Avery was with me the entire day. We were at the mall and then at the Fry Shack.
Did anyone help you look for the phone on March 6th?
Yeah, the entire mall staff, well, most of the mall staff in every store saw us, and the afternoon shift at the Fry Shack also.
No further questions, Your Honor.
Your Honor, if I may.
Any recross?
Yes.
All right.
Do you have any of these people who you claim to have seen you here today?
No, I do not.
So you have nobody to verify your story.
Well, I'm here to verify Avery's story.
So you have nobody outside of you and the person on trial for murder to confirm her alibi?
No.
No further questions at this time, Your Honor.
All right, thank you. The witness may step down. We'll turn to the final witness for the defense.
Your Honor, the defense calls the defendant, waiving her right to remain silent, Avery Becker, to the stand.
All right, go ahead.
Ms. Becker, can you state your name and spell your last for the record?
Avery Becker, Becker.
Thanks, Ms. Becker. Can you tell the jury a little bit about yourself?
Yeah, I went to Colorado High School last year. I was a student there. I've been on the mock trial team for about 4 years, and I really love it.
Can you tell the jury what being on the mock trial team was like?
Even though Mr. Brackman and I did not see eye to eye all the time, I really loved it, and I proved to be very talented at it. I loved giving crossings and closings. Those were my calling.
Was anyone else in the courtroom today a member of the mock trial team?
Taylor, Alex, and he's not technically in the courtroom today, but Coach Brackman. I'm sorry. It's really hard to believe that he's gone, you know?
Of course. Can you please tell the jury who Alex is to you?
Alex is one of my former teammates on the mock trial team. Alex and I do not get along and we don't really like each other. I don't know why Alex claims we're friends.
Now I'd like to move on to your relationship with Taylor. What was that friendship like?
Taylor and I were basically tied at the hip. We did pretty much everything together. She was the initial reason I joined the team, but not the reason I stayed on the mock trial team.
And can you elaborate on your relationship with your late coach?
Coach Brackman wanted his high school mock trial team to be the best of the best, which is something he typically accomplished, but he liked to give strict, he liked to have strict scripts and everything to be done up front. However, I like to go with the flow of the courtroom and just do a cross or a closing based off of that.
And what did this difference in opinions lead to?
Well, I was on B team, but he demoted me down. I was on A team, but he demoted me down to B.
And what happened after you were put on B team?
Well, I felt like as a senior and one of the best people on the team that I deserved to be on the best of the best. But Taylor and I were talking and she said that since she didn't care about mock trial nearly as much as I did and she knew the team needed me, she would step down and quit. So I went to regionals on A team and kind of forgot about the whole situation, but not what Taylor did for our team.
And how did you do at regionals?
Well, we actually were going to go to state. I got 2 awards. I got the award of the best closer and the award of best attorney. The case last year was these 2 siblings fighting over a will. And then the mom always dressed up.
Non-responsive.
Response?
This witness is directly answering the question of how our team did at regionals.
Your Honor, if I may.
Yes.
I see no relevance for the case pertaining to how they did at regionals. She's not answering the question. She's going outside of the question. She already stated how she did at her regional competition, and now she's going outside of the question.
All right, the objection's overruled. Thank you.
Ms. Becker, can you continue your answer?
Of course. So it was about this corgi dog that the mom always dressed up. I guess you could say that I was the best in show for my awards, or I had them feeding out of my paw. Get it? Because dogs have paws and there's things called dog shows. Anyways.
And after you won these awards, how did Brackman feel?
Coach Brackman made it very known that he disagreed with the awards that I got at practice. I previously had what I thought was a dry erase marker in my hand when he started his critique, so I left practice early.
And what happened after this?
Unfortunately, I did something really horrible. I wrote worst attorney on the hood of his Porsche.
And how did you feel after you wrote this on Brackman's car?
I felt horrible about it. Honestly, I don't even know why I did it. And I tried to apologize several times. I went to practice. I went to his work. I texted him. I tried anything to get back on the team. I just feel horrible because I not only let him down, but my team down. I wish I had a chance to apologize in person, but I can't.
Now I'd like to bring the jury to just before the 6th of March. Can you describe your activities on the day before the 6th?
Yeah, so Taylor and I were hanging out at the Fry Shack with a couple of mock trial kids, even Alex Cifuentes. And then we went to the mall, we looked around a couple of stores, and then we went home.
And what happened the morning of the 6th?
I woke up and I realized I didn't have my phone.
What did you do about that?
Well, I went to Taylor's house because she was there with me and she could help me look, and we were off to go search for it.
And so where did you start?
Well, we started at the mall. We were kind of looking around stores that we had been to previously. I'm sure I looked in a couple of plants somewhere. We were unable to find it though.
And so where did you go next?
We then went to the Fry Shack and we looked at the booths and everything that we were sitting at previously. and we were also unable to find it there.
How long did you spend looking for your phone?
The entire day, Taylor and I missed school to find it.
Were there any other measures you took in order to find your phone?
Yes, Taylor called my phone several times so we could maybe hear a ring, but we were unable to hear that ring.
Now I'd like to move on to some of the testimony heard earlier in this trial. Can you tell the jury about Markowitz's testimony on the cell phone tower data?
I know that my phone could have pinged near a cell tower. While it did do that, I was not with my phone. I am not my phone, and besides, I was across town looking for my phone with Taylor Perkins.
And do you have a comment about the alleged texts Alex Cifuentes claims were sent from your phone?
Alex, I never sent those text messages. Like I said previously, Alex and I are not really good friends, and I would not have told Alex that I was trashing into Brackman's house of all things. We are good friends, and I don't really like Alex.
Of course. But what happened to your phone, Miss Becker?
I have no idea. I lost it since then, and I've gotten a new one.
Of course. Now I'd like to discuss Blair Rollins with you. Are you acquaintances with Blair?
No, I don't really know Blair, but I do know that Alex and her hung out quite a bit from what I could see.
And is Blair in the courtroom today?
No, from what I understand, Blair mysteriously disappeared after Coach Brackman was killed.
And did you see the ring videos presented by the prosecution?
I did.
Were you in those videos?
First off, that outfit is a monstrosity. I would never go out in public in that outfit. Second off, and more importantly, I was across town looking for my phone with Taylor Perkins. I was nowhere near his residence, and I was across town.
Your Honor, permission to screen share Exhibit 1, which has already been entered into evidence.
Granted.
Ms. Becker, did you see this photograph earlier in the trial?
I did.
And can you summarize your reaction to it?
It's horrible. I knew that he was stabbed in the back, but I didn't realize it would look like that. He didn't deserve to die at all. He was a good coach, and whoever did that is a monster.
Avery Becker, did you kill Coach Brackman?
No, absolutely not. I haven't ever been to his residence, and I have no idea where he lives. After what I did to his car, I could never do anything like that to him again. I wanted to get back on the team, and that killing him would have never done that.
Of course. Your Honor, no further questions and permission to stop screen sharing.
Granted. We'll turn to cross-examination.
Yes, Your Honor. Ms. Becker, you've been on the Colorado High School mock trial team for 4 years now, is that correct?
I was on the Colorado High School team for 4 years.
In which you joined to have more time on your phone.
Which I joined to hang out with Taylor, and texting Taylor was just a part of it, not necessarily more time on my phone.
Mackenzie Brockman was your coach on that team, is that correct?
Yes, he was.
Your work was often called lazy,
He did call it that.
that you didn't put in the effort.
He said that.
Even though you won the Best Attorney Award during your regional tournament.
Yes, and the award of best closer.
He often rewrote everything you did.
Oftentimes, yes.
You thought his ego was really something.
It was at the time.
Even going to call Mackenzie Brockman a joke.
I called his license plate a joke. I wouldn't really call him a joke per se. He was a good captain, or he was a good coach.
A month before your regional tournament, your coach complained of your lack of preparation. Is that correct?
He did.
You started to say something back, but were promptly cut off.
I was.
You were then promptly demoted to B team. Is that correct?
Unfortunately, yeah.
Later, your best friend, Taylor Perkins, contacted you saying, if I quit, coach will have no choice but to put you back on the A team. Is that correct?
Well, she also said too that she didn't like the mock trial team as much as me, but yes.
And you're best buds with Taylor Perkins.
I am.
And you heard testimony from your best friend today in court. Is that not right?
I did.
Saying that You texted Alex Cifuentes?
Yes, but she doesn't know for a fact that I texted Alex Cifuentes. I did not text Alex Cifuentes.
Yet you deny that fact.
Yes, I do.
On March 6th, you and Taylor Perkins skipped school, is that correct?
Yes, we did. To look for
search
my
for your-
phone.
That you claimed to have lost the day before.
I didn't claim to have lost it. I did lose my phone. Yes,
You went to the mall,
we did.
to the Fry Shack,
Yes.
and you never found your cell phone, is that correct?
Unfortunately, no.
And during that entire day, you were only with Taylor Perkins.
I was only with Taylor Perkins, but there was other people at the mall and the Fry Shack.
Yet those people are not here to testify today.
No,
You don't have any physical evidence from the Fry Shack.
well, as I previously saw, Kuzak did have a napkin or something of that nature, but apparently that's not an evidence, so I guess that's a yes.
But it's not available for you to support your alibi.
Unfortunately, it's not.
Moving on, after your regional tournament, Mackenzie Brockman said that you didn't deserve your awards. Is that correct?
He did say that.
That you relied on your looks?
Yeah, one compliment, I guess, but yes.
You thought Brockman, your coach, would congratulate you.
I did, but as you can see, I was wrong.
And you got angry.
I got upset.
That you didn't want to keep being insulted by him.
I didn't appreciate it, no.
You then stormed out of practice
Yes, I did.
with a black marker in your hand.
Yes,
You then wrote across his Porsche in big, giant letters, writing worst attorney.
Objection, compound question.
Overruled.
You wrote worst attorney award. Is that correct?
it is. But as I previously stated, I'm I feel so much remorse for that event.
You thought that this would show him what you really thought. Is that correct?
I said that, yes.
Then Mackenzie Brockman came up behind you
Yeah,
and then began shouting
I guess it was an appropriate response, yes.
that you are off the team. You can join that loser Taylor Perkins and play video games all the time. Is that correct?
He said that, yes.
And that made you even angrier.
Yeah, it did.
Later that night, you had a conversation with your mother
Yes, I did. She's the absolute best.
where you made no mention of what you did to Mackenzie Brockman's Porsche.
No, unfortunately, I didn't.
You then told your mother you would get back at him if it was the last thing you do.
I said that, but it's not truly what I wanted.
But yes, you did say you would get back at him if it's the last thing you did. Yes or no?
Yes?
Thank you. No further questions, Your Honor.
Redirect.
Yes, Your Honor, but before that, could I get a time check?
Yes.
Miss Becker, on cross-examination, you heard a question about what you said to your mother. Would you like to address this for the jury?
I did say that to her, and I will never say that I didn't, but that's not truly what I wanted. After talking with her, and I realized that apologizing and working towards getting back on the team was the best possible thing I could do in this scenario.
How did you feel in the moments when Brackman was yelling at you?
It was pretty demeaning, but it didn't really affect my life. I was still a good mock trial player, and it put no motivation to kill him in my mind.
And how have those feelings changed since?
I am really upset about his passing. I really wish that I had a chance to apologize in person and not only have that state experience with him, but just seeing him as a coach one last time.
Thank you, Your Honor. No further questions.
Any recross?
Briefly, Your Honor. Ms. Becker, you mentioned on redirect examination that you felt sort of insulted by what Mr. Brockman said while he was shouting at you. Is that correct?
I said that, but I also stated that it led to no motivation in my mind.
And in your affidavit after that incident with Mackenzie Brockman, you state that made me even madder. Is that correct?
It did make me even madder at the time, but not now.
Is that your statement, yes or no?
It did make me mad. It did make me madder, yes.
Thank you. No further questions, Your Honor.
All right, thank you. The witness may step down. And we'll turn to closing arguments. Are folks ready for the closing arguments?
Yes, Your Honor. Your Honor, opposing counsel and members of the jury, revenge is a powerful motivator. Today, you have seen that on March 6th, Avery Becker, with the intent to burglarize and vandalize Mackenzie Brockman's residence at 444 South Flower Street, was based on revenge because she didn't want to be insulted anymore. She didn't want to have her work unappreciated. She snapped. She got angrier and angrier to the boiling point where she would break into Mackenzie Brockman's residence at 444 South Flower Street. So let me take you back to the events that happened on March 6th and before March 6th. Before the events on March 6th, you heard from Alex Cifuentes testify to Avery Becker's terrible relationship with her coach, that things were always rocky and that they would always argue. As you heard from her best friend, she wouldn't testify, she wouldn't lie to the police based on Exhibit 14 because she wouldn't lie about criminal activity. Then on March 6th of 2020, we showed you two expert witnesses who walked you through the events on March 6th. You heard from Detective Jordan Markowitz, who provided you the call detail records as well as the text messages from Alex Cifuentes. You saw that the call detail records show that Avery Becker from 1245 to 1255 was on her way to Mackenzie Brockman's residence as according to her demonstration on 15B. You saw that from 106 to 117, Avery Becker was at Mackenzie Brockman's residence at 444 South Flower Street. She was there. She wasn't searching elsewhere. She was there. Then you heard from Kyle Kuzak, who testified to the evidence based on Exhibits 7, 9, and 18 to suggest that a struggle had occurred, that it happened through a bear hug. And Avery Becker, because she was caught off guard by a burglary gone wrong, she sadly had to commit murder to prevent harm to herself. Now, the defense wants you to believe that Avery wasn't there. She was searching elsewhere with Taylor. But let's go back through their case. First, you heard from their expert witness, Professor Blake Van Owen, who has obvious bias against not only the police, but Kyle Kuzak. You heard her constantly insult Detective Jordan Markowitz, calling him defective or saying that he doesn't have the intelligence. That's bias, ladies and gentlemen of the jury. You also saw that her best evidence, her piece de resistance, Exhibit 22, she claimed to be Blair Rollins' testimony. However, when questioned with her statement closer to the events of March 6th, it was actually revealed that it was Jonathan Rollins' testimony in court, not Blair Rollins. How can her partial investigation be true if she can't even get what Exhibit 22 is about? Who is the declarant? She can't even get that right. Then you heard from Taylor Perkins, who said that Avery Becker did contact Alex Cifuentes, contrary to her best friend's words. They contradict each other. And she's also called here to testify for her best friend's alibi. She's contacted with the conflicting statements made both by Taylor Perkins and Avery Becker. You are forced to choose who is more credible. However, none of them are credible at all. You also heard that Avery Becker would be highly unlikely to leave her third kidney behind on March 5th. Highly unlikely. And that Avery Becker even said she joined mock trial for her phone, to have more time on her phone. Then you heard from Avery Becker herself, who testified that she got angry with Mackenzie Brockman to the point where she had the intent to vandalize Mackenzie Brockman's Porsche, even though she kept getting insulted. She made the conscious decision to vandalize the Porsche, whether it was with a permanent marker or a dry erase marker. Makes no difference. She said that she would get back at Mackenzie Brockman if it was the last thing she did. And that's exactly what she did. On March 6th, she broke into Mackenzie Brockman's residence through the back door and vandalized the property. However, she was unaware that Mackenzie Brockman was home and sadly had to commit murder. Ladies and gentlemen of the jury, the prosecution bears the burden of proving to you beyond a reasonable doubt that Avery Becker is guilty of first-degree murder and second-degree burglary. And we have absolutely met that burden. All the evidence points to Avery Becker beyond a reasonable doubt. Because revenge is a powerful motivator. Convict Avery Becker. Do what is right. Do not let revenge go unpunished. Convict Avery Becker. Find her guilty. Thank you.
Thank you, counsel. Defense?
Yes, Your Honor. Just real quick, are my time creepers ready? Okay, perfect.
You may proceed.
Avery wasn't there. She and Taylor were looking everywhere. My name is Jessica Bustillos, representing the defendant Avery Becker in this case. Today, we are all here to make sure that justice prevails. You are all warriors of justice, and it is time for you to keep the system working, and that starts by protecting the innocent. Avery wasn't there. She and Taylor were looking everywhere. On March 6th, Avery noticed her cell phone was missing. While someone else was killing Coach Brackman, Avery was with Taylor looking for the phone. She was nowhere near the Brackman house and did not kill her coach. Avery wasn't there. She and Taylor were looking everywhere. It is important to remember jury instruction number 2 while looking at this case. This instruction reminds us that the burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. The prosecution has failed to do that here today, and they have failed for one simple reason. You cannot find an innocent person guilty of crimes they did not commit. Jury instruction number 2 also says every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you, unless after considering all the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The reason these jury instructions exist is because we don't want an innocent person to get convicted. I urge you all to look at the evidence before you and the woman whose life is at stake and to make the right decision. Don't let a wrongful conviction happen here today. The prosecution brought forth 3 witnesses. They called to the stand Detective Jordan Markowitz. Detective Markowitz, an expert in cell phone data analysis, admitted that there is no way of knowing who was in possession of Avery's cell phone on March 6, 2020. Nor can Detective Markowitz confirm the authenticity of Exhibit 14, the text messages. Detective Markowitz also told you of the several calls and texts made to Avery's phone by Miss Taylor Perkins. The phone calls were so short that could only mean that the calls were not answered and neither the calls or the texts were returned. This proves that Taylor was calling Avery's phone in an attempt to locate it, and Avery wasn't in possession of her phone on March 6th. Detective Markowitz also confirmed that Blair Rollins' house is across from Avery's, and Blair would take the exact same route to Brackman's house as stated by Markowitz. You also heard from Kyle Kuzak, a crime scene reconstruction investigator who was unable to confirm for a fact that the murderer was Avery. Kuzak was only able to offer to the court that someone with the same general build as Avery killed Coach Brackman. And considering how many people share the same build, it is impossible to find Avery Becker as guilty. Just think, at Colorado High School alone, there's another person with a near identical build as Avery, that person being Blair Rollins. Kuzak only mentioned Avery once, which is weird considering Kuzak claims he's confident Avery is the murderer. They also brought forth Alex Cifuentes, a senior who was also on the mock trial team with Avery and Taylor. Alex failed to provide her phone for the investigation. Considering the modern era and the many ways that images can be manipulated, we are forced to reconsider the accuracy of Exhibit 14, the screenshots. Alex also admitted to not liking the defendant Avery. This kind of bias could easily be influencing Alex to lie about Avery, and the accuracy of her statement should be taken with a grain of salt. Next, 3 defense witnesses were put on the stand. First, we brought Professor Blake Van Owen, who showed the initial analysis done by Kyle Kuzak and Detective Markowitz was deeply flawed. Professor Van Owen was able to uncover dozens of mistakes made by the police. Professor Van Owen showed you that the investigation failed to consider other suspects and even manipulated their conclusions to help blame Avery for a crime she didn't commit. Blake not only proved Avery's innocence, but even brought forth a more likely suspect, Blair Rowlands. She showed you an audio clip from Blair's father who threatened Brackman and brought forth the fact that Avery and Blair had a very similar body type. Next, you heard from Taylor Perkins. Taylor confirmed that Avery couldn't have possibly committed the crime, seeing as they were together the entire day looking for Avery's phone. Finally, you heard from Avery herself. You'll see that Avery is a kind-hearted young woman with a bright mind. Avery has made mistakes in her past, but murder isn't one of them. Avery also confirmed that she was with Taylor all day on March 6th looking for her lost phone, and she has showed deep remorse for any previous tensions between her and Coach Brackman. Revenge is a powerful motivator, and that's why it makes no sense to blame Avery, a girl with no hate in her heart, especially when Blair Rowlands not only has revenge, but her father even swore it. We are all here to let justice prevail. The way to do that is to confirm what we all know, and that's the fact that Avery Becker is innocent. Avery wasn't there. Taylor looking everywhere.
All right, thank you. And I believe we're out of time for both sides, so let's just confirm with Mr. Downey we're completed.
We're going to take a recess here for scoring and to handle some coordination matters. I'm going to try and put the judges in a breakout room. Everybody be patient with me. I want to remind the scoring panelists that nobody should leave this meeting until they have clicked submit and we receive their score sheets. So hold on 1 second. So what do I do? Open this room.
So we're waiting on Judge Bain to come back in when he got knocked off.
Are all the participants still here? Good. I want to let you guys know we're trying to find our presiding judge, and I think I found him, so we'll be getting back to making the announcements here shortly. Judge Bain, I'm probably going to send you to a breakout room shortly and then have you come back in here and make the announcement. So hold on. Right. It looks like we have everybody here now and all the scoring panelists and our presiding judge. And so the presiding judge has some announcements to make.
All right, thank you for everybody's patience as we darted around the internet. And here we are coming back. First thing I'll say is what a phenomenal night. Really historic. I say this from time to time as we're in the middle of this pandemic. Tonight, you have made history. Seriously, by competing in the regional finals for mock trial in high school, it's history. And this is a moment I'm going to remember for the rest of my life. No exaggeration. Very close competition. The judges spent a considerable amount of time doing the scoring here. Difference by just between 1 and 3 points between the two teams. Ultimately, the prevailing party tonight is the defense team number 7. To remind you, so congratulations to team number 7. Team number 6, don't feel deflated. Both teams are going to the finals. Okay, so make sure you take tonight's experience and parlay it into doing better things as you get up to the finals. We're each going to take about 2 minutes to give some constructive feedback to you. Phenomenal cross-examinations by just about everybody. The whole leading question thing, you guys had it down pat. And rarely did you have to answer or finish your question, and isn't that correct? Really just phenomenal cross-examination. If you're on direct, if you're being crossed as the witness, one thing you might do is not even answer when the question is posed without really a question. You can just say, so was that a question? Just to kind of break down a successful cross. I loved it when attorneys and witnesses had voice inflection. It's good if you're a detective or a private eye to be monotone, just the facts. I'm not shading anything. But if you're an attorney or you're a different kind of witness, I love to hear the variety in the voices. You know, some up and down. Vary your tone so that you're more engaging for your audience. Again, some phenomenal acting. Loved the acting. Generally, I would not sustain, or generally I would not overrule some of the objections, especially where the two experts for either side are saying, yep, here's the person who did it, or here's why there's reasonable doubt to think they didn't do that. I would never allow that kind of testimony to be in court. And so you may get an objection on the next level and the judge might just sustain that. So be prepared for that. One last comment is, for every question that you have written down, anticipate what the objection is going to be. Literally, for every question you have, write down or think about what the objection might be. These are all really little criticisms. Phenomenal. I congratulate you for having the courage to do this. This kind of practice and work will really help you in the future. So congratulations to all of you. I'll turn things over to Ms. London. You're on mute.
Tried to. I have a positive statement and a negative statement for each of you, and I don't know, are you interested in hearing that? Okay, I'm gonna start with the prosecution. I'm gonna talk really fast so that we're not here forever. I thought, Ms. Inks, in your opening statement, you conveyed a lot of info. You're very thorough. You might think about breaking up your opening into little sections, because I think it'd be easier to understand in the next round. Mr. Danman, prosecutor 1, very methodical, organized. Your tone made you seem very trustworthy. I loved your tone. You could probably get away with a little more emotion because you're trying to prove murder. And I just thought, you know, it's a give and a take. So I did like your tone a lot. Witness number 1, Miss Nguyen, sorry. Your demeanor was awesome, very consistent. I loved your emotion and your passion, but you stayed very professional. So I thought that was fantastic. You're good at lecturing. I thought you seemed like a really legitimate expert witness. Very good. Prosecutor 2, Mr. Mayor, good job putting your spotlight on your expert. You got set back a bit with your objections, but like Judge Bain said, maybe if you anticipate some of those, there won't be so much of a lapse between answering those. But you gave your opponent time to restate and reinforce the expectations of the expertise of the witness. So that was, yeah, you let him talk about your witness's expertise by just letting him in his objection. So I thought that worked really well for you. You didn't jump in. Witness number 2, Mr. Fisher, excellent with the background and the training and the methodology. I thought you seemed like a really good CBI agent, or I thought you had a really good character. Excellent demeanor, don't change anything. Miss Inks, as prosecutor 3, your questions were very good at moving through the timeline. Maybe you could show more emotion, especially when your witness makes a really big point. Like I thought, you know, sometimes like when they made a really big point, it sort of got lost. But overall, very good organization. Miss Caruana, witness 3, I thought you were fantastic. I love the consistency between your words and your demeanor. And it was great how you got a lot of info in that was not asked. I thought that was perfect because it sets back the opposing attorney, sets them back on their heels. So I thought your character was really, really good. And then closing statements. Mr. Danman, you were fantastic. I loved your passion. I thought you revisited everything, the testimony, and retold the story really well. I thought maybe there was a little bit too much emotion at times because you're the prosecutor and you're trying to prove this really serious crime of murder. So I thought maybe at times it was just a little bit too emotional, but overall, really, really good. I loved how you wrapped everything up together. With the defense, Mr. Briggs, I loved your themes. I liked how you repeated words like lackluster. I thought that was really effective, and I wouldn't change that at all. It was nice to have it sort of grouped up in themes. Miss Bustillos, oh, these were the objections, sorry. Your first defense attorney was Miss Mans Jackson, is that right? Yes, I thought you were excellent. I thought your command of the rules was very, very effective. And I thought it came across, you seemed professional, you know the rules of evidence, you were on top of things. Maybe you could punch some of the words in your questions, because sometimes it seemed like you weren't, like, emphasize some of them, and just to split up your tone a little bit. And I thought that might be more effective. Miss DeFalo Daly, I thought you had excellent connection between your words and your demeanor. It was really helpful. Your tone, your attitude, it was all very consistent. I thought it was very good. Really nice witness testimony. Miss Bustillos, I thought you told a very good story through your questions. I thought they were organized and you hit what was important. You were good at overcoming objections, and you didn't try to do too much with your questions. I thought they were nice and simple, and it just seemed really effective, the way you moved through those. Miss Briggs, you seemed really earnest. I wanted to believe everything that you had to say, so I liked your demeanor, and stick with that. You were a very effective witness. Mr. Briggs, as defense attorney 3, I thought it was a good use of your prior testimony. You seemed purposeful and you understood what the other witnesses had stated. It was very strategic, like you were incorporating what they'd already said. And so it was very effective because you undercut some of the testimony of previous witnesses. I was trying to read my own writing, but so I thought it was strategic, and you could tell that you put some thought into what had just happened, because sometimes the trial happens differently than you think it's going to happen. And so it was nice that you were working with the facts as they came out. Miss Becker, Miss Hepner, I thought you were very good. I thought you were a little bit of everything, which is, I think, everyone's worst nightmare, because they didn't make much headway with you either way. I mean, that's just my take. That I thought you were consistent. You were very, very legitimate witness. Like, you stayed true to your character throughout. Closing, I thought it was a great tone. You conveyed how serious the charges were. You nicely, it was Miss Bustillos, right? Yeah, you tied everything together nicely. The themes, the specific selective evidence, and the jury instructions, the burden of proof. I thought you went through each thing very nicely, and I thought it was very, very effective. You just took pieces and split it all up. So all of you were fantastic. Thanks so much for letting me be a part of this. Very good. Best of luck next round. You guys will be fantastic.
Thanks, Ms. Linden. Ms. Kanice, just 2 minutes, please.
All right, I thought you all did a fantastic job. I was really impressed with your technical skills, the way you all put together, crafted your cross-examination, the way your opening and closing statements flowed. I was very impressed. You can tell that you've all put a whole lot of work into this. And then I liked your emotion too. I think you all did a really good job of putting forth enough emotion, but not too much. You didn't get combative with each other. You were very professional when you were arguing objections back and forth. Just an outstanding job to all of you. So you should be very proud of yourselves.
Thank you. Mr. McKenna?
I want to echo my colleagues and Judge Bain's statements. I think that you all did a fantastic job given the constraints. This is difficult when you're in person, and to have it by Zoom, I certainly echo Judge Bain's comments. A couple of things I would say overall. One, you know, so I'm an old Army lawyer, KISS, keep it simple, stupid. I think there are certain areas where, for example, the opening statement. First, as a lawyer, in this kind of situation, you prepare your closing first, you look at all the jury instructions, but in reality, the jury comes in, they've been asked a bunch of crazy questions about their personal life, and then they're a blank slate and you have to tell them a story. So there were a lot of 3 or 4 syllable words in the opening statements. They were good. And, you know, don't get me wrong, probably better than a lot of first-year attorneys, but tell your story. Just make it simple. Tell your story. The opening, I think that was for both of them. Unified theme, I think there was, you know, revenge was the big unified theme, but from my experience, if you hit it over and over and over again, the whole team hitting the theme really helps to drive it home. The defense, personalize the client. For example, the opening statement, personalize the client. We have a young man here who did this, he did that, he did this, blah, blah, blah. You want that jury to identify with your client. Couple of technical things, cross-examination, beware of cementing the, you know, you've got an expert who's testifying against your client and you're going to spend 4 minutes cementing his or her qualifications. If your cross-examination is, you're just guessing anyway, and you know the judge is going to admit the expert witness, maybe you just save that and just at the end, and then just to echo some of the statements, really technically very good, but crescendo, build it up, and then primacy and recency. Your first question has to hit the mark, and then your last question should hit the mark. And that's the theory of primacy and recency, that the jury will remember those better. But final point, style, be yourself. I think you all really did a very good job of that, but when you're getting into a territory where you're trying to mimic somebody else or to be an actor, just be yourself. And I think you'll do great in the next round. Thank you for allowing me to participate.
All right, thanks, Mr. McKenna. I know it's late for you all. Last thing I want to do is thank the coaches who might be watching, thank the parents for their support. And last but not least, thank Jason Downey, the attorney who has spent countless hours basically every year for the last 10 or 12 years, organizing this wonderful, wonderful competition. Thank you, Jason, for everything. And if there's nothing else, I think we'll disconnect.
Your Honor?
Yeah.
Just on behalf of both teams, I'd like to thank you and all the other scoring panelists and Jason for putting this together and giving us this opportunity, especially on the virtual platform. It's been an honor to be able to continue doing this program. So thank you.
You're nice to say that. This is history. Enjoy it. It's in the record books.
Yes, indeed. Thank you so much for judging all of you and making this a wonderful competition.
All right. Well, thank you all very much. Let's all disconnect